Walpole Fall Annual Town Meeting. My name is Tom Brady, Walpole Town Moderator. There being a quorum of more than 76 town meeting members present, please come to order. Please rise for the Pledge of Allegiance. Okay, we ended on Monday night. I had read Article 17, and then there was a motion to adjourn, and we adjourned. So again, we're at Article 17, and it's a motion as moved, as set forth on the screen before you. It's a 2/3 vote that is required. And can we have the the Finance Committee? Yes. It was 83 when I left. Finance Committee on Article 17, how did you vote?
Finance Committee voted favorable action, 11-0-0.
Board of Selectmen?
Board of Selectmen voted favorable action, 5-0-0.
And the Planning Board?
At the October 1st meeting, the Planning Board voted 5-0-0 favorable action.
Thank you. Any discussion? Yes, sir.
Bill Finucane, Precinct 6. I thought use variances were illegal.
Excuse me, I didn't hear what you said, sir.
Use variances were ruled illegal in 1970s, were they not?
Mr. Moderator, through you, under Chapter 40A, Section 10, there is the ability for a town meeting to adopt a zoning provision to allow a zoning Board of Appeals to grant use variances, but you need to do so expressly through town meeting vote. If the bylaw is silent, then 40A, Section 10 provides expressly that there is no use variance allowed. So that did happen in the 1970s. That is when that came in. But what it said was, unless you expressly say that the use variance authority is there, it's not there.
My other question is, I'm not sure I like the idea of the building inspector alone being charged with it will, whether it will be detrimental to injurious to person's property or improvements in the vicinity of the town. I don't think one person should make that ruling on such a variance. That's all.
Thank you. Yes, sir.
Robert O'Leary, Precinct 3, through you, Mr. Moderator. Since it won't be through the Board of Appeals, will the abutters be notified, is my question.
Building Inspector, would you like to talk to that?
Through you, Mr. Moderator. No, this is just an attempt to loosen up regulations where this is a temporary use for under 180 days, and the Board of Appeals process could take 3 to 4 months. Again, this is an attempt to loosen up the regulation and allow for these types of uses. There would be no notification, but if the applicant were to come in and apply to go over 180 days, that would automatically trigger the necessity for a Board of Appeals hearing, which in turn, based on 48, would require the notification of abutters within 300 feet.
Thank you. Any further discussion? All those in favor of the motion on Article 17, please say aye. Aye. All those opposed? No. It is a vote. Article 18. It is moved that the town amend the zoning bylaws, Section 5B, 5I, by deleting the words reserved for future use and inserting in place thereof the following: brewery, manufacturing of all types of craft alcoholic beverages, including but not limited to wine and malt beverages, not exceeding 15,000 barrels per year, may or may not contain a tasting room, restaurant, or bar. And further, by inserting capital X under the RA, RB, GRR, and PSRC headings, and by adding A under the B, CBD, HB, LM, and IND headings. And further, to amend Section 5B footnotes by adding the words, "2, if such use is located within the CBD, it shall contain a restaurant," to said footnote section. This requires a 2/3 vote. And FinCom?
FinCom voted favorable action, 1101.
Board of Selectmen?
Board of Selectmen voted as amended, favorable action 500.
And the Planning Board?
And October 1st, as amended, voted 500, favorable action.
Thank you. Yes, Mr. Pittman?
Larry Pittman, Precinct 1. Well, I guess this is, and help me understand this is for like a brewery-type pub or a small brewery, and would they have to be licensed to operate as part of this whole process?
Through you, Mr. Moderator, yes, there are different levels of licensing for breweries. There's farm brew, there's a brewer's license. There are multiple different facets of licensing that the applicant, so the use is through the town, the license would be through, I believe, the state at this point for a brewery. So there is another level of regulation that they'd have to get through before they would be able to open up a brewery, so to speak.
Any further discussion? Yes, sir.
Yes, Joe Monahan, Precinct 1. What I can't understand is even if it's on the outskirts of the town, not in the very center of town, someone spends $200,000-300,000 to make a brewery. Why are they being forced that they'd have to have a restaurant? It's like the Sharon Day Camp Center that we bought, and nobody has been able to use it, and nothing's being done with that. But nobody's forcing that, okay? Which I think the people should enforce it. And I think it should be, as far as the daycare center, should be leased out, take the liabilities off the people in the town, and have a discounted fee for the people to use it. This has been almost a year on the Sharon Daycare Center, but now you're trying to force someone who maybe wants to have a brewery just outside of town, but you're going to try and force them to have a restaurant also? And nothing being done on the other end? I mean, it's like a two-sided thing here.
Any further discussion? Mr. Spillane.
Spillane, Precinct 6, Sewer and Water Commission. Contrary to Mr. Monahan, this day camp is being used now. We've had a couple of big feats up there for the town. The Little League Baseball played there this spring.
What is your point of order, sir?
No disrespect, Ron Ardeen, Precinct 2, no disrespect to my colleague, Mr. Spillane, but this has nothing to do with this article whatsoever. We're talking about this, we're not talking about water and sewer or the property we purchased last year.
Yes, I agree with your point of order. Thank you.
I just wanted to respond to the other gentleman there.
I understand.
I go out every year to the Berkshires. We go out deer hunting out there, Great Barrington. There is a brewery right there in Great Barrington with a restaurant. It's a beautiful little place. It's not a downgrade to any section of town, really. So
Thank you.
That's all I have.
If you turn around and force them to open a restaurant, you're talking another $100,000, which may not happen for that person to open that brewery. I don't know if any of you have businesses, but when you're putting out $200,000-300,000 and you're taking a chance, and you may go down the tubes, and you may make it, hopefully you make it, But when you add another $100,000 on, that means a lot to somebody.
Mr. Moderator,
Yes.
for you, just a point of clarification. So the restaurant portion, if a brewery were to open in the CBD, we made it a requirement that you would have to open a restaurant if you're only in the central business district. This is just a new look at an existing use. If you look at 5B, 5P in the zoning bylaw, we currently have alcohol manufacturing as a use with no restrictions, no 15,000 barrel restriction, or no restaurant restriction. So you could theoretically go ahead on the outskirts of town, so to speak, and open up a alcohol manufacturing facility. So this, again, is just a new look at an existing use with a little bit more restriction if you are opening it, for instance, in the middle of town.
Yes.
In regards to Precinct 3, just a little clarification since we're on the subject. Is this for just the manufacture and resale of brew on the property, or would it be sold? To what would this apply? What kind of, an establishment that sells it on the property?
No, a brewery could sell it off the property also. But if you see, so the main use is a brewery, and then that's why we added in the central business district, which is different than the existing use 5B, 5P. If it were going to be in the central business district, we don't want just a manufacturing facility. We want something that's going to provide an amenity to the downtown district, so we required the restaurant there. So again, theoretically, you could open up just a manufacturing facility, but that is the existing use that we have under 5B, 5P.
So if a manufacturer wanted to just manufacture and sell off the property, they would still be required to open a restaurant, to have another business? If it was in the central business district?
If they're in the central business district, yes. And that's, that goes along with the intent of the zoning in the CBD, which is not to have manufacturing facilities, but to have amenities that are available to, constituents, to users of downtown district, rather than just having, manufacturing. That's why we have IND districts and LM districts.
And this applies to smaller breweries because it would be less than 15,000.
Correct.
So you want to put them in the same category as a large manufacturer?
This would be considered what's called a microbrew at this point, and that's why the 15,000 barrel limit is there. That's a national standard that limits manufacturing to these microbrews. So this isn't Anheuser-Busch or Stoli or, Sterling Vineyard. This is small scale.
Okay. I would have to say that I do agree with Mr. Monahan that I don't think we should force a small business that's manufacturing malt beverages, and if they're not selling it on the premises, I would not consider that like a large-scale manufacturing facility that would take away from the downtown area.
Thank you. Mr. Pittman.
Larry Pittman, Precinct 1. Question on CBD. I know the other night it was mentioned in that article, in particular mentioned the CBD downtown only. In this article, does CBD also include East Walpole business, the business area?
Mr. Moderator, through you once again a clarification. So the East Walpole is not, contrary to some comments the other night, is not in the CBD. It is a business district, and it was treated the same. I'm not sure what town meeting, the parking requirements were treated the same for the business districts, where the parking requirements were waived for businesses in both East Walpole and the CBD, but it is not a central business district in East Walpole.
Thank you.
Thank you.
Guyette, Precinct 6. One of the discussions we had at the FinCom was on this article in particular, the amount of water that would be used by a brewery. 15,000 barrels per year would be the equivalent of 465,000 gallons of water just in the production of the beer alone. And I know if one were to come into town, it would need to go obviously in front of the Sewer and Water Commission as part of the planning. But I was curious if we could get the Sewer and Water Commission's input on if something like this would even be feasible, considering the situation we're in with our water, and there's been some talk of even further water restrictions. Thanks.
Thank you.
Explain Precinct 6 and the Water Commission. 460,000 gallons a year is a drop in the bucket. We've actually pumped over 4 million gallons in a day. It wouldn't affect us.
Thank you. Any further discussion? There being none, All those in favor of the motion on Article 18, please say aye. Aye. All those opposed? No. It is a vote. Article 19. Article 19 is moved as set forth on the screen before you. It requires a 2/3 vote. And FinCom?
FinCon voted favorable action 1101.
Board of Selectmen?
Board of Selectmen voted favorable action 500.
And Planning Board?
At the October 1st meeting, the planning board voted 500 favorable.
Thank you. Any discussion? Yes.
David Salvatore, Precinct 4. If we could just have the building inspector perhaps explain the purpose of each article as it comes up, it might speed things along. Can you explain why we're doing what we're doing?
Mr. Moderator, so you want me to explain, you want me to read what's on the...
No, in general, why you're making the changes that you're suggesting.
Okay, so these particular definitions were not contained previously in the bylaw, and they're common definitions, some of them. Other ones, which everyone likes to harp on somewhat, like second degree of kinship, comes out of recent case law, and it just gives us the ability to enforce overcrowding or issues such as that with lodging houses a little bit better. So these are definitions that either came out of new uses that we provided for, or they were to bring the bylaw into the modern era, so to speak. So.
Thank you. Any further discussion? There being none, all those in favor of the motion on Article 19, please say aye. Aye. All those opposed? It is a vote. Article 20. It is moved that the town amend the zoning bylaw section 6C, point 11 by deleting the strike-through text and inserting the bold text as follows. Nothing herein shall prevent the projection of eaves, chimneys, or cornices not encroaching more than 18 inches into the setbacks, unclosed porches, decks, porticos, or stoops not encroaching more than 48 inches into the setbacks. Uncovered steps, windowsills, or belt coursers are not limited but shall not come within 5 feet of any lot line. This requires a 2/3 vote. And the Finance Committee?
Finance Committee voted favorable action 1200.
Board of Selectmen?
Board of Selectmen voted favorable action 500.
And the Planning Board?
Yeah, October 1st meeting, planning board voted 500 favorable action.
Thank you.
Mr. Moderator, through you, once again, this is a proposal that actually was set in motion the previous fall town meeting, and it didn't make it to the floor, or there was an issue with it, but the issue is with decks. We had afforded for porches in this particular section of the bylaw, and a porch is more dense of a structure than a deck is. So in interpretation, you would say a porch, which is a roofed structure, is allowed, but a deck would not be allowed. So we just put decks in there to make it easier for architects, homeowners, engineers to read and understand that you can, in fact, use a deck as a projection into a setback.
Thank you. Any further discussion? There being none, this requires a 2/3 vote. All those in favor of the motion on Article 20, please say aye. Aye. All those opposed? It is a vote. Article 21. Move that the town amend the zoning bylaw section 13.2.e by deleting the strike-through text and inserting the bold text as follows. All uses requiring a special permit under section 5B, except for 1, 2, and 3 family residences, uses or activities that do not involve any changes to the exterior of the structure, and for those uses or activities specifically exempt from site plan review and other sections of the zoning bylaw. FinCom.
Favorable action 1101.
Board of Selectmen.
Board of Selectmen favorable action 500.
And Planning Board.
Planning board, October 1st meeting, 500 favorable action.
Any discussion on Article 21? There being no discussion, this requires a two-thirds vote. All those in favor say aye. Aye. All those opposed? It is a vote. Article 22, it's moved that the town amend the zoning bylaw, Section 5G1, Paragraph 3, by inserting the bold text as follows. Pending a review of topography, buffers, and other site conditions, the planning board may waive these buffer requirements to allow smaller buffers or to establish the location of buffers to the extent that such buffer areas will substantially further the purpose and intent of this section. Finance Committee.
Finance Committee voted favorable action, 1101.
Board of Selectmen.
Board of Selectmen voted favorable action, 500.
And Planning Board.
Planning Board at the October 1st meeting voted 500 favorable.
Any discussion? There being no discussion, all those in favor of Article 22 motion, please say aye. Aye. All those opposed? It is a vote. Article 23. It is moved as stated in the projector slide beside me. Finance Committee?
Finance Committee voted favorable action, 1200.
And Board of Selectmen?
Board of Selectmen favorable action, 500.
And Planning Board?
At the October 1st meeting, the Planning Board voted 500 favorable action.
Thank you. Any discussion? There being no discussion, this requires a two-thirds vote. All those in favor of the motion on Article 23, please say aye. Aye. All those opposed? It is a vote. Article 24. It's moved that the town amend the zoning bylaw, Section 5, use regulations as follows. Amend Section 5B1F by inserting subsections I, small family daycare, parentheses, in the home. Amend Section 5B1F by inserting subsection 2, large family daycare, parentheses, in the home. Amend Section 5B footnotes by adding the words 3, small and large family daycare, parentheses, in the home, facilities shall be subject to limited site plan review in accordance with Section 13 of the zoning bylaw, as well as all other applicable local, state, and federal codes and regulations. This requires a two-thirds vote. Finance Committee?
Finance Committee voted favorable action, 1200.
Board of Selectmen?
Board of Selectmen voted favorable action, 500.
And Planning Board?
October 1st meeting, the Planning Board voted 500 favorable action.
Thank you. Yes?
In regards to Precinct 3, the limited site plan review, was small family daycare not subject to that prior to this request, this amendment?
Mr. Moderator, through you, so this article is an attempt to bring, again, the bylaw into line with the state law. 2007 or 2008, late 2007, early 2008, the state went from allowing 6 for in-home daycare to allowing 10. In counterintuitive, Mass General Law usually says, as Town Council alluded to, if you don't afford for a use, it's usually not allowed. This is the opposite. It actually says in Mass 40A that if you do not regulate it, then it's allowed as of right. So previously, what we had defined, and we regulated just through definition, was that you could have only 6, and we didn't regulate 10 at all. So this is an attempt, one, to let people know that yes, you can have 10, which we never had in the bylaw, and then as a matter of safety, we allow, we're requiring limited site plan review, which previously was not required, which will give us the ability to go ahead and look at 2-car driveways or single driveways. Somebody could open feasibly a 10-child daycare on Main Street, and you have 10 vehicles pulling up at 7 o'clock in the morning, 7:30 in the morning. And that would allow us to go ahead and phase drop-off times, look at turnarounds, look at how many vehicles are actually entering and exiting, and then look at a parking spot, because once you go to 10, the daycare provider has to have an assistant on site also. So it allows us to look at those things. And limited site plan is not a full board review. It's staff level, fire department, police department, building department, engineering, health possibly, planning department will take a look at it and make sure that what's being proposed is in fact safe, not only for the user of the lot, but for the abutters.
So the limited site plan review would be for 6 and under for the small family daycare?
It would be for both, for 6 and 10.
Correct. If someone is starting their own business and they anticipate having 6 or fewer children to care for, and they don't have a driveway or they don't have anything, what does the town come up with a plan for them, or what's the solution so that they can continue on or start their business?
Right, so we currently go through this process now. It's just not memorialized, it's not in black and white. We just had a recent application come in, and it was for 10, and it is a 2-car driveway, and it's on a street that abuts a condominium association, a townhouse association, and what we did was we had them lay out a pickup and drop-off schedule. They showed us where the assistant was going to be parked, and then where the parents, where the caretakers were going to come in and drop off the children in what time. So what they do is provide us with essentially an affidavit saying this is how we will operate. We review that. Right now it's at the building department level. At the limited site plan, we'd open it up to the other town departments. And then we would take that and put it with the permit and issue them a certificate. Once we issue a certificate, the state licensor will then issue them a license to go ahead and open up the daycare.
So I guess my question truly is, why are we exposing or requiring a small family daycare with 6 or fewer to the same standard as, I can understand with more children, 7 to 10, where there might be an issue with traffic patterns or drop-offs, but why are we requiring the small daycare? So it seems like we're drawing them into the same requirement as the large family daycare.
Right, so the original proposal was not to have the small family childcare have limited site plan review, but in discussion and public hearing, it came out that we probably should require that both go under the same review. I did a survey of 12 towns, abutting towns, up Route 1, 1A, 95, and most towns actually require special permit for both uses. Some do not require any regulation other than full site plan review for small as well as large, but most require a special permit for both, if not special permit and full site plan review. So we're kind of in the middle here with what we're doing. It's a necessary use, you need to have it. We're a blue collar community here, a lot of working parents, so it's definitely a use that's needed. However, we have had complaints, and we have gone out and looked at existing daycare, and it was voiced to us that we should probably be taking a look at these drop-off and pickup locations as a matter of safety only.
My opinion would be that small family daycare should not be subject to a limited site review. I think it would place an undue burden on, and you gave the example of for the 10, but I would imagine that 6 or fewer would be insignificant in terms of drop-off issues or traffic pattern issues.
Thank you. Yes, sir.
John Murta, Precinct 5, member of the Planning Board. I commend the Commissioner for his work on both these large and the smaller daycare. Safety is paramount where there's when we're locating a daycare centre. You have to have means of egress, and you have to have means of getting children there safely and getting them out of there safely. So we have a lot of streets in the town of Walpole, 8 foot wide, 10 foot wide, 12 foot wide. We need a limited site plan review. I think it'll help the situation. It'll be more transparent, and it'll be good for everybody, good for the abutter. Thank you.
Thank you, Mr. Murtaugh. Any further discussion? There being no further discussion, all those in favor of the motion on Article 24, please say aye. Aye. All those opposed? No. It is a vote. Article 25. It is moved that the town amend the zoning bylaw, section 2.7B, paragraph 1, by deleting the strike-through text and inserting the bold text as follows. Beginning on the effective date of subsection 2.7 of the zoning bylaw, no building permit for new single-family residential construction shall be issued unless in accordance with the regulations contained herein. This section of the zoning bylaw shall be in effect until December 31st, 2020, at which time it shall automatically cease to be effective unless otherwise extended for a longer period of time in accordance with applicable provisions of Massachusetts law. This requires a 2/3 vote. Finance Committee?
Finance Committee voted favorable action, 1101.
Board of Selectmen?
Selectmen voted favorable action, 500.
And Planning Board?
At the October 1st meeting, the planning board voted 500 favorable action.
Thank you. Any discussion on Article 25? There being no discussion, all those in favor of the motion on Article 25, please say aye. Aye. All those opposed? It is a vote. Article 26. It's moved that the town amend the zoning bylaw, section 13.7B2, by deleting the strike-through text as follows. The planning board shall hold a public hearing with the applicant, period. The notification requirements for the public hearing shall conform to the requirements listed under section 2.2A of this bylaw. Finance Committee?
Finance Committee voted favorable action, 1200.
Board of Selectmen?
Selectmen voted favorable action, 500.
And Planning Board?
Planning board voted 500 at the October 1st hearing meeting.
Thank you. Any discussion? Yes, sir.
Richard Peeler, Precinct 7. Why was the time period deleted? What's the thinking behind that?
Through you, Mr. Moderator. This was an attempt to help things as far as internal flow in the planning department. Applicants won't experience any change whatsoever. They will still receive their decision within the 65-day time frame. What this does is it enables the planning department to have ample time to run the advertisement and open the public hearing while receiving comments from the other town departments. What we've been experiencing as of late is that sometimes the public hearing, the way that the dates work out, would end up being maybe the 37th day or the 38th day. And then that causes applicants to have to come back to an additional hearing. So this would enable applicants to get their decision hopefully within one meeting, and they would still receive their decision within 65 days. That time frame has not changed. It's more of an internal housekeeping type matter.
Okay, thank you.
Thank you. Any further discussion? There being no further discussion on Article 26, all those in favor of the motion on Article 26, please say aye. Aye. All those opposed? It is a vote. Article 27. It is moved that it is set forth on the screen before you. This is the sign regulation motion. Finance Committee?
Finance Committee voted favorable action, 1101.
Board of Selectmen?
Board of Selectmen voted favorable action, 500.
And Planning Board?
Planning board voted 500 at the October 1st meeting, favorable action.
Thank you. Any discussion on Article 27? There being no discussion on Article 27, this requires a 2/3 vote. All those in favor of the motion on Article 27, please say aye. Aye. All those opposed? It is a vote. Article 28. It is moved that the town amend zoning bylaw section 12, 3B1 by adding section O, cemeteries for humans and animals, to the end of said section. This requires a 2/3 vote. Finance Committee?
Finance Committee voted 12-0-0. Favorable action.
Board of Selectmen
Board of Selectmen, favorable action, 500.
and Planning Board.
At the October 1st hearing, the planning board voted 500, favorable action.
Thank you. Any further discussion? There being no further discussion on Article 28, all those in favor of the motion on Article 28, please say aye. Aye. All those opposed? It is a vote. Article 29. It is moved that the town vote to impose a temporary moratorium through midnight, October 31st, 2016, on any and all future permits issued under Section 10D of the Walpole zoning bylaws entitled Open Space Residential Development by adding the following paragraph under a new Section 3B, Authority, in an effort to hold public hearing on Section 10D during the moratorium period in order to allow the town sufficient time to address complex legal and planning issues and also to consider issues of procedural clarity which have been recently identified and which may be addressed through future amendments. Section 3B. Notwithstanding any other provision in the Town of Walpole zoning bylaws to the contrary, no application or OSRD special permits may be accepted. No subdivision or division of land will be eligible for consideration as an OSRD, and no special or building permits may be issued for the construction of any non-permitted, non-approved OSRD until after the 2016 annual fall town meeting. The purpose of this temporary moratorium is to allow sufficient time to engage in the planning process to address complex legal and planning issues and also to consider issues of procedural clarity. Finance Committee.
Finance Committee reconsidered this article at our public meeting, and our vote was 12-0-0.
Thank you. Board of Selectmen.
Board of Selectmen voted favorable action as amended, 500.
And Planning Board.
Planning board voted 302 on the October 1st meeting, favorable action.
Yes, Mr. Pittman.
Pittman, Precinct 1. Can we get an explanation on the 3-2 vote or what this all means, please?
Mr. Conroy?
Well, I was one of the abstainers. I abstained, and my reason is we have one in front of us, so I don't want to get us in a legal tangle one way or another, tipping your hand, so to speak. So I just said, I'm not going to give any opinion.
Thank you. Yes, Mr. Muraski. Oh, yes.
Thank you, Mr. We're off to a great. Thank you, Mr. Moderator. Muraski, Precinct 7, and the author of this article, which is a citizen's petition for town meetings information at the Finance Committee public hearing, and after consultation with legal counsel, town council, the end date of this article was changed so that the moratorium actually ends on Monday, October 31st, 2016. It was believed that a specific date would be more amenable to the Attorney General's office. And the petitioners and my fellow neighbors who have signed the petition that made this into an article agree with that determination. I'd like to give you a very short presentation, shorter than I usually give, and I was told to be very brief, and I've been very busy up back, cutting back a lot of things. So if I'm a little disjointed, just please bear with me. Basically, Article 29 calls for a one-year moratorium on open space residential developments, better known as OSRDs. And the moratorium, the purpose is to provide the town with an appropriate amount of time so that the planning board may hold public hearings, to gather information from the public in order to amend the OSRD section of the bylaws. Now, obviously, we just can't amend those sections and then they become changes. Obviously, any amendments would have to be represented to this body, to the town meeting, hopefully no later than the fall annual town meeting of 2016. Now, I don't know how familiar everyone is with respect to the OSRD section of the zoning bylaws. It's a rather lengthy section. It goes on for 10 pages, and it starts on page 69 of the zoning bylaws. To sort of briefly describe what that section contains for everyone, it's obviously the purpose or the intent of OSRD is to allow for greater flexibility in the design of residential developments and to encourage the permanent preservation of open space. Now, OSRDs are only allowed in certain districts. They're allowed in the rural zone, they're allowed in Residence A, and they're allowed in Residence B. And a developer needs a minimum of 20 acres in order to apply for an OSRD special permit. And there are a whole host of hoops to jump through with respect to pre-application conference, a 4-step design process, planning requirements and procedures, and design standards. The OSRD section of the bylaws was first approved by town meeting on April 10th, 1989, 26 years ago. And I was told that it was taken literally from a state template. So it contains very generic language, and it wasn't tailored to the town of Walpole. So as the Board of Selectmen like to say, we're looking for an opportunity to Walpoleize this section. Some examples of land that were developed as an OSRD in that 29-year period include Toll Brothers off of Mylord Street in Precinct 1, Christina Drive also in Precinct 1 off of Main Street, and most recently Ross Common in Precinct 8, which is the old Sunny Rock Farm development. And that's basically how I got involved and my neighbors in this article by attending years of meetings and ping-ponging ourselves back and forth from planning board to sewer and water to conservation back to planning board. I think we believe ourselves to be honorary members of all those committees. This proposed moratorium applies only to Section 10D of the zoning bylaws, no other section. It doesn't affect any other type of development, only open space residential development. And the moratorium also applies only to future applications for an OSRD special permit. So if a person was given a special permit for an OSRD by the Walpole Planning Board, which is the granting agency, that is not affected by this proposed moratorium. So basically, there's one such special permit in existence, and it was granted by the Planning Board on May 27th, 2015, and so the permit is valid for 2 years. And that company that was given that permit is basically in a definitive subdivision approval process, and so that's an ongoing public hearings with the Planning Board, and now for the first time with the Conservation Commission. Now the question is, why do we need this moratorium? And I'll be quite honest with you, I had prepared a very lengthy discussion about this because I always believe that sharing thorough information is better than being brief, because then everybody understands where we're coming from. However, in this particular case, at this particular time, at this particular town meeting, I was told, to basically keep it short. But perhaps the most important reason has to do with how and when lots are counted. In order to come up with an open space residential development, you need to first, as a developer, submit a conventional yield plan. That is, what would you have been allowed to do if you didn't do an open space development? And that determines the number of lots. Well, we've run into a situation where the conventional yield plan, where there have been quite a few disagreements with how many lots you can build in a conventional yield plan, and how lots are counted in a conventional yield plan, and whether or not existing homes on an already approved lot can be counted in a conventional yield plan. So we need to really look at that section and have some public hearings on that section, and the town needs to clarify that section for other neighborhoods. We also need to review and clarify the section of the bylaw, or that particular OSRD bylaw, that deals with the role of the Conservation Commission in terms of wetland determinations and how and when the Conservation Commission should be brought into the process. When you first filed for an OSRD, our Conservation Commission did not hold a public hearing, and the developers believed that they didn't have to have one. And when you don't have a public hearing, the public doesn't have a chance to voice their concern. Also, a third reason why we need to have a moratorium is we need to look at the effect of OSRDs as they relate to contiguous undeveloped parcels, both in terms of changing the character of a zone and the possibility that smaller house lots of 8,000 square feet in an area where larger house lots of 40,000 square feet are located, and could cause the owners of the larger lots to file and receive abatements that all taxpayers would have to pay for. And I could go into that in a little bit more detail if someone wants to, but from my discussions with the town appraiser, that's called economic obsolescence, where some type of outside force affects your house, your assessment, when you didn't even do anything to your house. And the fourth reason that we believe that we need a moratorium is we need to clarify how and when waivers are given by the planning board in an open space residential development plan. We have requirements in this town for street length and street width, and we need to make a determination whether or not we are going to be committed to those requirements. Otherwise, we could be helping developers, quite frankly, enhance their lot count. So those are four reasons. There are other reasons why open space, why this section needs needs to be reviewed. My presentation before the Finance Committee was a little bit shy of 2 hours, and with a lot of questions. And I think they were very sympathetic to what the neighbors have had to go through with respect to the challenges of this section. This is not just a Precinct 8 problem, if you want to call it a problem. The assessor's office prepared a spreadsheet for me showing all the possible sites within the town of Walpole that could fall under an OSRD zone. And that spreadsheet identified 872 acres of land and did not include Norfolk County Aggie parcels, which, if they were included, would bring the count up to 1,163 acres, or 8.6% of the total acreage of Walpole. And some of this land that was cited by the assessor's office are in other precincts. They're on County Street, North Street, High Street, Sunny Rock Drive, Fisher Street, Lincoln Road, Moose Hill Road, Elm Street, Baker Street, Old Post Road, and Winter Street. So as you can see, they're in a majority of the precincts that we represent. That's a significant amount of land that could be developed under the guidance of a bylaw that, quite frankly, is subject to too much discretion and too much interpretation. And it also does not include land or parcels, OSRD parcels, that could be created as a result of future land sales through the assemblage of abutting parcels. So in order to get you 20 acres, developers could take multiple parcels and put them together, and there's no way of knowing and being able to count those parcels in this. So basically, this article just allows a time to take a deep breath, have the planning board basically hold some public hearings and allow anybody and everybody to go and testify about open space, what they would like to see in an open space development bylaw. And then let the planning board, let the town staff rewrite the section, and if that is where the direction goes, and represent it to the planning board for a second public hearing or third public hearing, and then present it to town meeting with any amendments and changes. So we hope that town meeting supports this article, and if there are any questions, I would be more than happy to answer them. Thank you.
Thank you, Mr. Moreski. Yes, sir.
John O'Leary, Precinct 3. Just a clarification. I believe Finance Committee said they voted 12-0-0, but you didn't say whether it was favorable action, no action?
It was favorable action, excuse me.
Thank you.
Philip Zakarowski, Precinct 7. I just wanted to see whether the planning board could respond, and what do they see the issues, just to kind of get a balanced view, just to understand a little more what, from the town perspective. Because one of the purposes certainly of the whole zoning was to facilitate affordable housing and open space, and certainly that's a very an admirable thing too. So I just want to get a sense if what does the other town boards see this as such a big problem?
Mr. Conroy, would you like to speak to that?
I was one of the two.
Okay.
I'll defer to Alana, is because we have something in front of us, should we even be, as the 5 members, even be talking about it? Are we treading on thin ice, or should we just remain? The question is, Alana, should we be going into this why we think it's good or bad or indifferent, given the fact that we have one coming up on the next hearing? That's my concern.
Through you, Mr. Moderator, certainly the planning board or a planning board member is not required to respond to individual questions. I think the issue really relates to the scope of the article and what it is that's appropriate to be discussed in relation to it. And certainly the moratorium, as you and I just discussed, the scope of the article is whether there should be a moratorium of 1 year or not about what may be done or won't be done, but just why the moratorium is necessary and what issues likely would be explored during the moratorium.
Okay. So we don't need a report from the planning board. Anybody else like to discuss? Yes, sir.
Yeah, Philip Zagorowski, Precinct 7. Yeah, just to be a little clearer, I wasn't asking for them to report on the article from, from an official perspective, but I was just curious, do other boards see issues with the way this zoning option has been specified? So in other words, we've heard residents see a problem, and I'm not questioning that, but just curious to see, do other town officials see this as an issue that we need to address? And I just wanted to get any other input from town officials or the town planner or whoever might be appropriate, or from the finance committee. Are people saying that we agree that there's been defects in the way this has been written, and a lot of projects have gone through that we wish didn't go through, or just want to see what problem we're trying to solve?
FinCom?
Yes, through you, Mr. Moderator. The issues that Mr. Moraski brought before us were many, and as he said, he spent a long time with us. He sharpened the issues now to 4 that he's identified for you tonight. I think the reaction, if I can speak for the majority of the FinCom, was that he raised a sufficient number of issues that ought to be investigated. I don't think anybody at this point is saying, oh, we think it should be changed from A to B, or we think this should be changed, or we're not talking in specifics right now, but rather the need to have a public airing of the issues that Mr. Moraski and his neighbors identified for us at FinCom. Now, maybe at the end of the day and after a number of hearings, the people are satisfied with the status quo, but perhaps there are changes as discussion goes on and hearings are held that seem to warrant either a change or a modification or further delineation. And so I think that our reaction was, these are issues, they seem to have merit, and there should be further discussion. No one is at this point saying, we think this should be changed, or that should be changed, or this is the specific end goal. I will say, however, that the legal counsel advice we received from town council was that we did have to have a date certain, and Mr. Moraski changed the petition so that there would be a date certain. You can't have the moratorium without having a definitive time for it to end. And the other issue is that the town really has to act. You can't have a moratorium and then sit on your hands for the 12 months. So if this does pass tonight, if it's the will of town meeting to pass this article, then there needs to be action so that the hearings are held and there's discussion and we come to some kind of a conclusion before October 31st, 2016.
Thank you, Ms. Lawson. Yes, Mr. Hamilton.
Hamilton, Precinct 5. I just want to reach back to Adams Farm. When we had to exercise, we had the opportunity to exercise our 61A rights to purchase Adams Farm, it was open space. But when an open space subdivision was approved, the value went from $3.5 million to $7 million. Now, I'm not complaining about that. The town still voted to purchase it. What I find that was a problem was that the open space subdivision contained property that the value of was included in our purchase price, but was land that we did not get title to. So I'm saying that a good hard look at this is, I think, long overdue. Thank you.
Thank you. Yes.
Valancourt, Precinct 5, also a member of FinCom. Just want to provide a little more information about the FinCom meeting and certainly echo largely what Ms. Lawson testified or agreed to earlier. The only item I'd like to add additional emphasis to was the issue of waivers. I think that is an area that was highlighted in Mr. Moraski's speech and presentation, and many of the finance members are are in agreement that that is an area that certainly needs to be reviewed and public hearings need to be held. So that was my recollection of our discussion, so I just wanted to point that out.
Thank you.
Mr. Moderator?
Yes, Mrs. Tucker.
If I may, and I'm speaking on behalf of myself, even though, as amended, the Board of Selectmen voted 5-0-0 for favorable action. One of the things that takes place as a community matures is the land that is left available becomes more and more marginal. And what you end up with are an enormity of variances. And those variances, in my mantra, is variances are for hardships, not for friendships, nor are they there for profitizing. And that's what needs to be watched. Thank you.
Thank you, Mr. Snuffer. Any further discussion? There being no further discussion on Article 29, all those in favor of the motion on Article 29, please say aye. Aye. All those opposed? It is a vote. Yes, that was a unanimous vote. Article 30. It is hereby moved that the town authorize the Board of Selectmen to, 1, enter into net metering credit purchase agreements with the owner of a solar photovoltaic facility to be installed on a privately owned parcel of land in the town of Walpole for a term of up to 30 years, and on such terms and conditions, and for such consideration as the Board of Selectmen deems in the best interest of the town, and 2, take any other actions and execute any other documents necessary, convenient, or appropriate to implement and administer such agreement. This requires a majority vote. And FinCom?
FinCom voted favorable action 9-0-0.
And the Board of Selectmen?
Board of Selectmen voted favorable action 5-0-0.
Jim, would you like to talk to this?
Yes, if you don't mind, Mr. Moderator, through you. The next two articles the town meeting is being asked to consider relate directly to a town meeting vote dating back to last fall. Last fall, town meeting voted to authorize that the Bird machine site and the Bird landfill site, the landfill site is located just off of West Street. The Bird machine site is located in South Walpole, just off of Washington Street. We voted to have a solar voltaic overlay district on both of these specific sites. So over the last year or so, we've been negotiating with two of the parties. One is UGT and the other one is Washington Gas and Electric. They are responsible for these, further developing these sites. Article 30 specifically asks town meeting to authorize the Board of Selectmen to enter into a net metering agreement. What is net metering? I never heard of it until about 9 months ago. That's a service that allows certain customers to generate their own electricity to offset the electricity usage. In this case, the town of Walpole is going to be the buyer. UGT will be the seller. And it is only specific to the Bird machine site. It's going to actually be taking marginal land that's just sitting there right now. I believe we collect limited property taxes on right now, just the land, and turning it into a green usage. If we were to do nothing and vote down both of these articles, nothing would happen. They would not be developed further, and both of these solar companies would likely walk away. That's what they indicated to me. We worked with our pilot committee and the Board of Selectmen to negotiate these agreements. I'm pretty satisfied with what is being presented to you today. It's a culmination of about 9 or 10 months worth of work. So I'll be happy to take any questions. And all you're doing tonight is just authorizing the board to enter into agreements on these items.
Thank you, Mr. Johnson. Yes, sir.
Guy at Precinct 6. I know at the FinCom, we went into a little bit about what the net metering benefits would be, if you will. Can you go into a little more of what the expected benefits are in terms of dollars, et cetera?
Sure. Right now, we are expecting a cash-out option is what Eversource has determined that we must go with. It's determined by NSTAR prior to Eversource taking over, wanted to provide the town with credits, meaning we just get a discount off our monthly electric bills for the Willis treatment plant for this building. Eversource has decided, which is their right to do so, to simply give the town a check at the end of each month. We've projected, we worked with Bay State Energy Consultants and Town Council. Our projections figure about $190,000 per year that will eventually come in, we'll book in, it'll eventually turn out to free cash. That is a conservative estimate. I'm optimistic it could be a little bit more, but for now, I'm comfortable at $190,000 per year, just on the net metering aspect.
Thank you.
Yes, Mr. Murtaugh.
Yeah, John Murtaugh, Precinct 5. You can call me Mr. Green if you want, but I've been a big supporter of solar for a long time, and I want to congratulate everybody involved in the pilot agreement. It was impressive. Well done, Jim. Thank you.
Thank you, Mr. Murtaugh. Anyone else? Any further discussion on Article 30? FinCom, your vote?
FinCom voted favorable action, 900.
Board of Selectmen?
Favorable action, 500.
Any further discussion? There being none, all those in favor of the motion on Article 30, please say aye. Aye. All those opposed? It is a vote. Article 31 is moved that the town authorize the Board of Selectmen to enter into one or more pilot agreements for payments in lieu of taxes pursuant to General Laws, Chapter 59, Section 338H(b), or any other enabling authority, one for each owner of a solar photovoltaic facility to be installed on privately owned parcels of land in the town of Walpole, shown on Assessor's Map 52 as Parcel 78 and Assessor's Map 40 as Parcel 116, with each agreement being for a term of up to 30 years and on such terms and conditions and for such consideration as the Board of Selectmen deems in the best interest of the town, and 2, take any other actions and execute any other documents necessary, convenient, or appropriate to implement and administer such agreement. This requires a simple majority vote. FinCom, how did you vote?
FinCom voted favorable action, 900.
Board of Selectmen?
Board of Selectmen, favorable action, 500.
Mr. Johnson, would you like to speak to this, sir?
Sure. Again, this Article 31 covers pilot agreements, which stands for payment in lieu of taxes. The first one, which is the Bird Machine site, the first year amount brought in will be about $100,000, and I would be remiss to mention that we are also recouping our legal fees for, in this agreement, in the Bird landfill agreement and the prior agreement. So we're recouping about $35,000 or so $1,000 in that, and it's going to be, it goes from $100,000, drops down to $45,000. The thought on that one is we're going to get the most amount that we can up front, and then slowly raise it by 2.5% per the levy limit going up. And similar type of issue here with the Bird landfill site. That one we actually were fortunate to negotiate $90,000 up front, and then go down to $26,500. I will note that currently we collect about $3,000 of taxes into that. This specific site is for a 2.35 megawatt plant, so we just rolled the property taxes into everything. That's why it's $26,500. And I'll be happy to take any questions.
Any discussion? There being none, all those in favor of the motion on Article 31, please say aye. Aye. All those opposed? It is a vote. Article 32 is moved that the town take no action on Article 32. All those in favor that the town take no action on Article 32, please say aye. Aye. All those opposed? It is a vote. Article 33, it is moved that the town take no action. All those in favor that the town take no action on Article 33, please say aye. Aye. Opposed? It is a vote. Article 34. Yes, Mr. Deeney. It's a motion to dissolve the town meeting. That takes a majority vote. All those in favor? Oh, point of order, yes.
There's still an article to be discussed. We can't dissolve until we get through all the articles, I believe.
No, if a motion to dissolve is brought up, you can dissolve. It's non-debatable, that's correct. So there is a motion to dissolve on the floor. Is there a second? Yes, sir? There's a second in the back. Okay, this requires a simple majority vote. All those in favor of dissolving this meeting, please say aye. Aye. All those opposed? No. Back to Article 34. And Article 34 was a motion that the town refer back to petitioner, but there has been a substitute motion provided by Mr. Hamilton, and the substitute motion states to see if the town will vote to amend the Water Resource Protection Overlay District aquifer zones to conform to the Department of Environmental Protection aquifer zone names by renaming all Area 2 aquifer zones to Zone 2, the greater than sign, 40 feet, and amending all references in the Walpole Resource Protection Overlay District to Area 2 to the new name Zone 2, greater than 40 feet, by renaming all Area 2 aquifer zones to Zone 2, less than 40 feet, and amending all references to the WRPOD to Area 3 to the new name Zone 2, less than 40 feet, and by renaming all Area 4 aquifer recharge zones to Zone 3, and amending all references in the Water Resource Protection Overlay District to Area 4 to the new name Zone 3, or take any action in relation thereto. Actually, it's a petition of John O'Leary, or Mr. Hamilton. Yes, sir. Okay.
Several months ago, Walpole residents successfully fought off a significant threat to our water supply in the form of a cemetery on top of our aquifer.
Excuse me, Mr. Hamilton, I'm sorry to interrupt you. I didn't ask the planning board for a report on this article.
Did I hear you say correctly this is a substitute motion or a clarified motion?
This is a substitute motion.
We didn't vote on a substitute motion.
You voted on the...
Is it, well, I'm getting confused. Is this what was presented to us, or is this something new tonight?
This was in the town warrant, and then it was
Okay, so
presented...
it's not a substitute motion then. It was what we heard then. Is that correct? Okay.
Yes.
All right. And the planning board voted 5-0-0, no action on October 1st.
Thank you. Board of Selectmen?
Board of Selectmen voted no action, 5-0-0. And please repeat the clarification. Is this intended to be a substitute motion to a citizen's petition?
Yes.
We had the hearing. If it's a substitute motion, we didn't conduct a public hearing based upon the substitute motion. I'll defer to town council on that.
I believe you're out of order then.
Mr. Moderator, through you, if the substitute motion is to move the article as it was presented in the warrant, then that is what the planning board heard, and that is what is before the meeting. If it's different from what is in the article, then that wouldn't be something that the planning board heard, and you would not have a planning board report on that.
I believe
that would be the issue.
The motion was what was the planning board heard, because this is a photocopy from the town warrant.
So, Mr. Moderator, through you, then I understand that the main motion was to refer back to the petitioner, but the substitute motion that would be before the body would be to move instead the article as written in the warrant.
That's correct. So that would be the main motion?
That's the substitute motion before the body. There's a motion to refer back to the petitioner, but now there's a substitute motion to instead move the article as written in the warrant. So that's what would be before the body as
Okay.
the substitute motion.
So there's a substitute motion before the body to allow his substitute motion that was written in the warrant.
His substitute motion is to approve the article as presented in the warrant. That's
Okay.
what I understand. That's what I understand it to be.
Yes, so that's what we should be discussing.
For clarification, Mr. Moderator, through you, the issue isn't whether to vote it favorably now. The issue is whether the substitute motion should be, whether that should be the main motion.
Yes.
So
that's the votes that's
the initial
before us,
issue.
whether the substitute motion Mr. Hamilton's presented to me should be the main motion. So that's what our discussion should be about. Mr. Hamilton,
Thank you.
Mr. Hamilton, we have to vote on whether this is going to be allowed as the main motion.
But I can speak to it.
Mr. Moderator, is there a second, please?
Is there a second on that? Yeah, there's a second on Mr. O'Leary's. But the motion that's before you is whether we should allow this substitute motion to be the main motion. So that's what our discussion should be about. And that's all. Okay.
Okay. But the fight to protect our water supply is not over. Town meeting must make sure that cemeteries can no longer be built in areas that would endanger our aquifer. We saw with the now defunct cemetery proposal, the town is vulnerable when our aquifer zones are not consistent with the state's aquifer zones. The Mass Department of Environmental Protection, based on a misunderstanding of our aquifer zones, had declared that the cemetery in our aquifer would not endanger our water supply. In order to address this problem, this article brings to the Water Resource Protection Overlay District into conformity with the state naming conventions. Only aquifers that supply water to public wells can be designated Zone 2 and be protected by state law. However, Walpole's aquifer is designated Area 2 and Area 3 and provides water to our public wells, but is not stipulated Zone 2 and thus was not protected by the Department of Environmental Protection. It was not clear to the Department of Environmental Protection that that our Area 3 was actually a Zone 2, and they approved a cemetery in our public water supply, aquifer. Mass General Laws 114, Section 35, restricts cemetery use in Zone 2, and the Department of Environmental Protection should not have approved it. Without evidence, it would not contaminate our public water supply. Murphy's Law, if it can go wrong, it will, and it did. Common sense demands that we fix this terrible flaw in our Water Resource Protection Overlay District tonight. And Article 34 will do just that. By simply renaming our town's Area 2 to Zone 2, greater than 40 feet, and Area 3 to Zone 2, less than 40 feet, our Water Resource Overlay Protection District will ensure that the added protection of the Department of Environmental Protection and state law will apply to our aquifer. If this article fails, Walpole water rates payers will have to bear the cost of the experts needed to defend any threat to our water supply. This article is a no-brainer. and it also changes Area 4 to Zone 3. It is important to note that this article leaves all water resource protection overlay district regulations and boundaries unchanged. No regulations or boundaries are affected by Article 34, as it only changes the aquifer zone label names to conform to the state definitions. All the science and hydrology used to document our Water Resource Protection Overlay District stands unchanged. Our aquifer qualifies as a Zone 2 and should be so stipulated, as this article proposes to do. Another important example of the need for consistency between our aquifer zones and state statute is seen in the Spectra Energy's proposal to route a second gas pipeline through Walpole, paralleling their other gas pipeline. This type of activity in our sole source drinking water supply can be disruptive to our water supply. We need Article 34 to ensure the Environmental Protection Agency and the Department of Environmental Protection act on Walpole's behalf to apply state and federal law to protect our drinking water to the full extent of the law. By approving Article 34 tonight, we let every interested party know the town's Zone 2 and Zone 3 boundaries, ending all confusion and providing the drinking water protection our people want. Mass General Laws, Chapter 114, Section 35, prohibits cemeteries in Zone 2. The study performed by Wesson and Sampson in response to the cemetery proposal confirmed that the proposed cemetery was up gradient of our wells heads, and water from there will reach our wellheads in 6 years and 9 months. Therefore, the cemetery was proposed on land in our Zone 2. Area 2 label names and Area 3 label names together represents Walpole's Zone 2, as stated in 310 CMR 22.02, definition of a Zone 2. Article 34 will stipulate our Zone 2 label names and Zone 3 label names accurately in our Water Resource Protection Overlay District, eliminating all confusion on the town, state, and federal level. A Zone 2 is a wellhead protection area that has been determined by hydrological modeling and approved by the Department of Environmental Protection. Drinking water program. In cases where hydrological modeling studies have not been performed and there is no approved Zone 2, an interim wellhead protection area is established based on the well pumping rates or default values. Certain land use may be either prohibited or restricted in both approved Zone 2s and interim wellhead protection areas. The Department of Environmental Protection and the Secretary of Environmental Affairs approved Walpole Zone 2 when they approved our Water Resource Protection Overlay District, because our Area 2 and Area 3 meet the state definition of Zone 2. Zone 2 was the original label name until separated into two label names, Area 2 and Area 3. In all cases, Zone 2 shall extend up gradient to its point of intersection with non-pervious material. Groundwater flow divide, a contact with till and bedrock or recharge boundary ends the aquifer. The study performed by Weston and Sampson confirms that the proposed cemetery was up gradient in our wellheads, and water from there will reach our wells in 6 years and 9 months. Therefore, the cemetery was proposed on land in our Zone 2, which was defined as Area 3. By approving Article 34 tonight, we let every interested party know the town's Zone 2 and Zone 3 boundaries, ending all confusion and providing the drinking water protection we need. It is important to note that Article 34 leaves all water resource protection overlay district regulations and boundaries unchanged. Thank you.
Thank you, Mr. Hamilton. Yes.
Well, there are some slides if anyone wants to see the law, and there is a copy of the letter approving the cemetery incorrectly.
Mr. Abbott.
Thank you, Mr. Moderator. I rise to speak opposed to the substitute motion, and because what it's proposing, I believe, is going to cause confusion as well as being misleading. And as most of you are aware, the town does define 4 areas of our aquifer that we're attempting to protect. And some of you may be aware that the state defines 3 zones with the same objective to protect our aquifer. What this article is proposing is that we just change the references to Area 2, 3, and 4 in our bylaw to use the term Zone 2 and Zone 3. And with the effect that the applicants believing that this will result in our areas acquiring the protection for land uses that will that we wish to restrict as they apply to the state's Zone 2. Unfortunately, just saying something will be Zone 2 doesn't make it so. And what I would refer to is the state zones are defined in the state's 310 CMR section 2202, and Zone 2 is defined, and I'll just read the first sentence because I think it's the most important. Zone 2 means that an area of an aquifer that contributes water to a well under the most severe pumping and recharge conditions that can be realistically anticipated. And then in parentheses, 100 days of pumping at approved yield with no recharge from precipitation. What they're defining is the worst possible conditions that can possibly realistically occur. So there is a slide that that I provided that shows both the state as well as the town maps, and if we could bring that up, Jim.
Mike, will you just go to the next slide? This is what Mr. Abbott presented. This is both the town map and the state map side by side.
Okay, thank you. As you can see on the left, it's the state zone. The areas, the little small green purple dots are where our wells are. That's the 400-foot radius, including they actually have identified the 3 Medfield wells too. So they are very familiar with where our aquifer exists. The sort of yellowish color is the Zone 2, and the remaining section, the turquoise, is the Zone 3. On the right side, you have the town's map, and you can see we're covering a bit more. Again, the small orange dots there are our wells. The yellow, there's 2 yellow sections, that's our Area 1, which, again, we're looking at when all the wells are pumping for over a 180-day period where the drawdown is. Slightly different than what the state uses for its determination of Zone 2. I think the key being the state says no precipitation to recharge the wells. Our Area 2 is the blue areas, and if I can point them, I'm not sure if this, maybe it's too bright. Well, no, wait a minute, there it is. The blue areas, there's one way up here. You can see the red dot. There is another one right down here. There's one here, and there's one here. If you compare the 2 maps, you can see that the one in the section, this oval shape, is not identified as a Zone 2. And this is where I think that we're, just by simply renaming, never mind you that Area 3 and 4 clearly don't line up with the yellow side on the left, where it's Zone 2. We clearly have at least one of our Area 2s that are outside of Zone 2. That's part of the thing that I think is misleading. It's more evident when you look at the Area 3, and that's this sort of pinkish area that you see right here that starts down in South Walpole and winds its way up into the center of town and then goes up into North Walpole. This Area 3, by naming it a Zone 2, clearly does not line up with the definition that's in the state regs, and you can clearly see that it's significantly larger than what the states identifies as Zone 2. So again, we're going to be labeling an area that does not comply with the definition in the state's regulations. One thing that you should be aware of, the reason that we have as Area 2 is that is intended to protect potential well sites. This is a flaw that the state regulations do not address. And the reason we have it is so that you don't want to inadvertently allow some land use that would then preclude you from using a perfectly good site for a well because of some sort of land use that should be restricted. The reason that our Area 3, and again that's this sort of pinkish area, is so large is not only is it up gradient from our existing wells and has some protections in there, it's also designed to protect the areas that are up gradient to Area 2, such as this area here, and this area down here. So in summary there, what we're trying to do, or what Article 34 is attempting to do, is to call something a Zone 2 that clearly doesn't meet the definition of a Zone 2. And I think that it would cause confusion for people if they said they're in the Zone 2. You'd immediately have to ask, did you mean the state Zone 2, or did you mean one of Walpole's Zone 2s? I think the appropriate way to address areas such as the cemetery is what we did in Article 28 earlier this evening. If it's something that we want to restrict, we should restrict it to, as the Article 28 does, we add it to a list of restricted items. So that's the reason that I think that we should go with what the Finance Committee originally talked about. I guess you decided to go no action? Yes. There was some discussion at the meeting it was to refer back to petition. That's what I think we should go with. And in addition, we should probably look going forward to see if this bylaw has any other problems. But this simply just doing a simple change without it meeting definitions is not the way to go, and I believe actually could cause us to have lawsuits, as if we started saying, well, this is a Zone 2, doesn't meet the state definitions, certainly we would be contested on that. By the way, I didn't introduce myself, Bill Abbott, Sewer and Water Commission. I want to also say that the Sewer and Water Commission didn't take a position. I'm speaking only on myself there. Thank you.
Thank you, Mr. Yes.
Well, first of all, Mr. Abbott is incorrect. Article 28 does not affect religious cemeteries. Religious cemeteries can be put anywhere in town. Only the DEP can restrict religious cemeteries. And I believe that's correct. Do you disagree with that, Mr. Abbott?
Well, I made no didn't make a statement that it stopped cemeteries. What I was saying is that the way Article 2 was addressing it was saying, in our aquifer, which is basically what you see on the right side, we don't want this particular land use, whatever it may be.
But it doesn't prevent, if a cemetery is proposed within our drinking water, Article 28 doesn't stop it.
And neither would just arbitrarily saying, we're going to change our bylaw, we'll just make everything that is listed as an Area 2 and Area 3, we'll just call it Zone 2 and expect that the restrictions that the state definition, which clearly is different, you can look at the two maps, and say that these land use restrictions still apply because we've decided to arbitrarily make something a Zone 2.
Chapter 114 Section 35 states, "No land other than so used and appropriated on April 10th, 1908, shall be used for the purpose of burial, if it be so situated that surface water or ground drainage therefrom may enter any stream, pond, reservoir, well, filter, gallery, or other water use as a source for public water supply." So the only way you can stop a religious cemetery from locating on our aquifer is have it stopped by the Department of Environmental Protection. That's my understanding. You differ from that.
Well, no, that may be true, but what we're doing here is we're changing our aquifer protection overlay information in our zoning to just arbitrarily call sections Zone 2 and expect that the same restrictions that the state Zone 2 applies, but it doesn't meet the definition that those restrictions are based on.
I think, did you read the requirements for Area 3 and Area 2?
Yes, I did.
And that's a thickness of aquifer of, on average, greater than 40 feet or less than 40 feet. Is that not true?
That is correct. Area 2, the reason we wanted it more than 40 feet was that if it's for a potential well site, you want to have sufficient stratified drift, that's the loose sand and gravel deposits, so that it would be worthwhile to even have a well. That's the only reason for the 40-foot.
That's not accurate. When we were getting and formulating the Water Resource Protection Overlay District, we defined Zone 1, Zone 2, and Zone 3. And when we went to Mr. Mello, who was then town administrator, he said that he would not want to have such restrictions all the way through the whole aquifer. So we had to go back to the Secretary of Environmental Affairs and ask them, could we have two separate rules of regulations for a Zone 2? Could it be divided? And he said you could, but you could only divide it by geological boundaries. And we had done a study as part of the study for the Water Resource Protection Overlay District that found that the most deep areas, the ones that were 40 feet or more, were good locations for wells. But we didn't make Zone 2, Area 2, that definition because we wanted to. We made that definition because it was requested by the town administrator, and the Secretary of Environmental Affairs agreed to it. Now, the
Point of order, Mr. Moderator.
Yes, what's your point of order?
With due respect to my fellow bills in Precinct 6 and 5, I just want a clarification as to whether the debate now is moving into the merits of the proposed article, and we've moved just beyond the field of whether or not the article should be the main motion.
I could certainly summarize mine in a sentence, and then I'd be happy to sit down.
I think this might be a good debate to continue, but it just should be continued within the scope of whether this is the article or not, and not whether this should be. I think both points have been duly made as to the need or lack of need to review the article.
Mr. Moderator, through you, my objection is that we are attempting to rename some areas without basically very arbitrarily, just making changes that one could do with word processor, rather than in such a way that it does not meet the definition of a Zone 2 as defined by the state, and that's not the way that it should be done. You could challenge the Zone 2, how it's defined, but all we're trying to do, what's being proposed is let's just change the names and then we'll be covered, and I don't believe that's true. Thank you.
Hold on, Mr. Hamilton. FinCom wanted to speak?
Yes, when Mr. Hamilton came before us on our opening public hearing, which was last Thursday, we did not have him or Mr. O'Leary for the original scheduling that they were originally supposed to come. We listened to him for approximately 45 minutes, and we finally said enough that, you know, he may have a lot of legitimate points, but at this point, he's not able, this isn't ready for prime time. There's more work that has to be done to it. I'm not saying that it's not legitimate, what his concerns are, but we don't know, and we haven't had any legal opinions given as to what he wants to do. Can he even do it? So there were a lot of questions, and we, at that point, took a vote and decided to return the article to the petitioner to be decided at another point.
Thank you. Mr. Conroy.
I'm not going to debate the article one way or another at this point. I will ask town council. I think it was our opinion that the way the article is written would not pass the muster of the Attorney General. And if you ask the town council, because we could debate it all night, you think it's wonderful, it's not. If it isn't written in the proper format, it's just going to get tossed. So that needs to be answered first.
Ms. Quirk.
Mr. Moderator, through you, the article certainly, as a petitioned article, it does not conform to the usual form to say, trying to amend the zoning bylaw in particular places and in particular ways. You know, certainly it would be worthwhile to have that discussion in the event that someone, you know, goes through and does that work to show where it needs to go, where the amendments need to go. That is certainly a technical problem, that this does not tell you exactly where that would go. So that is a problem, certainly is a problem. And the underlying issue with respect to what's been raised is a factual matter as to where the different areas are on the maps. And so, you know, obviously I have to defer to the water commissioner who spoke earlier as to those factual aspects.
Thank you. Mr. Hassenjager.
Yeah. Hassenjager, Precinct 1. A couple points. These maps cost millions of dollars and took years to produce with hydrologists and scientists. This is not something a citizen comes up in front of the room and decides to redraw maps and relabel the maps. Our water supply is protected. It's protected in the nines with the state DEP of Massachusetts. They protect everything. We have an entire cadre of water experts and a commissioner of our water department, as well as a sewer and water commission. And they haven't participated in any kind of public hearing, meaningful debate, or analysis of any of this. We need to rely on the experts. If anyone's going to change any maps, we need to have extensive hearings, bring in the DEP, bring in scientists, bring in all the parties and all our local experts to analyze this. This is not some casual change or language adjustment that someone makes. And it's sort of a scare tactic, I believe, and unfair to try to use the cemetery example to scare people about a risk to the water supply. And I think this definitely should follow the FinCom's recommendation to be remanded back to the petitioner.
Mr. Murtaugh.
Yeah, let me first say our aquifer and our water district is the most precious resort we have in this town. But having said that, I don't just think I'd agree with the FinCom. I don't think it's ready for prime time, but a healthy discussion like tonight is always good. We can only add to it and compliment Bill for his actions and for his knowledge. Thank you.
Mr. Moderator, through you. It is incorrect to say that our aquifer does not meet Zone 2 regulations. CMR 310 22.02 is a Zone 2 by definition. That area of an aquifer which contributes water to a well under the most severe pumping and recharge conditions that can be realistically anticipated, 180 days of pumping at safe yield with no recharge from precipitation. It is bounded by the groundwater divides which result from pumping and well and by the contact of aquifer with less permeable materials.
Mr. Hamilton.
Mr. Moderator?
Yes.
Padel, Precinct 2. Could we move the vote on the whether to make the substitute motion the main motion?
Yes. Is a motion to move the motion. There's a second. Requires a simple majority. All those in favor, say aye. Aye. Opposed? No. It is a vote. So now the vote before you is whether to accept the substitute motion as the main motion. That is a simple majority vote. All those in favor, say aye. Aye. All those opposed? No. No. So the substitute motion is gone. And now the main motion is that the town move to refer back to petitioner. And any discussion? All those in favor? Aye. Opposed? It is a vote. And that... Yes, Mr. Deneen. Move to dissolve. All those in favor? Aye. Opposed? Great. See you in the spring. Thank you.